Hey folks, welcome back to the channel. Today's case is a tragic one that reminds us how quickly life can change with a single decision. We have a mother who, after the profound loss of both of her parents, made the devastating choice to drive under the influence of benzodiazepine and fentanyl, resulting in an unimaginable accident, taking the life of her child and leaving her to face charges including vehicular homicide. She's now headed to prison. However, in a rare and powerful show of empathy, the judge created a path that balances justice with the hope for healing. This is an emotional journey of grief, grace, and a chance at redemption, even in the darkest of times.
And we'll get on the record. This is 21 SC 179011 and 23 SC 191989. Both cases involve Ms. Vaughn, who's here in court, along with her attorney, Ms. Rios. And we have Mr. Shapiro here for the state. Ms. Vaughn, in just a moment, Mr. Shapiro is going to put you under oath and then ask you some questions about your rights as a criminal defendant. Make sure you answer his questions truthfully and completely, but also make sure you let Ms. Rios or me know if you have any questions or if there's anything going on that you don't understand, okay? Great, and when you do answer, make sure you speak up, because Ms. Rivers needs to be able to hear you.
Okay.
All right. When you're ready, Mr. Shapiro.
All right, thank you, Judge. Ms. Vaughn, would you please raise your right hand? Do you swear or affirm that any statements or testimony that you will give in the matter now before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can lower your hand. And Ms. Vaughn, if you want to lean into that microphone a little bit and speak up, okay? Would you begin just by stating your true and correct legal name for the record?
Shaquita Vaughn.
And are you at this time taking or under the influence of any medications, drugs, or alcohol?
No, sir.
Is there any medication that you normally take that you have not taken or been given today?
No, sir.
How old are you, Ms. Vaughn?
32.
And how far did you go in school?
In 10th grade.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Ms. Vaughn, do you understand that you are charged in two separate indictments in two separate cases?
Yes, sir.
And do you understand that in indictment number 23 SC 191989, you were charged with one count of murder in the second degree, 2 counts of homicide by vehicle in the first degree, 2 counts of serious injury by vehicle, and 2 counts of cruelty to children in the second degree?
Yes.
And do you understand that in case number 21 SC 179011, you were charged with a single count of theft by conversion?
Sir.
All right, Ms. Vaughn, do you understand that you have the right to plead either guilty or not guilty to all of those charges?
Yeah.
And do you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove all of these charges against you at a jury trial? Have you had enough time to speak?
Yes. Oh, yes, sir.
And again, ma'am, if you'll just speak into the microphone a little louder so she can hear you, okay?
Okay.
Okay. Have you had enough time to speak with your attorney about all of the facts and circumstances in the 2 indictments that are pending against you?
Yes, sir.
Do you need any more time to discuss the cases with your attorney?
No.
And are you satisfied with your attorney's services?
Yes.
All right, thank you, Ms. Vaughn. And Ms. Rios, are we waiving a formal reading of the indictments for purposes of the plea?
Yes.
And are we waiving any and all defects in the indictments for purposes of the plea?
I'm unaware of any defects, but I do waive for the purpose of the plea.
Okay, thank you, Ms. Rios. Now, Ms. Vaughn, has your attorney advised you of the potential minimum and maximum penalty to each offense to which you are entering a guilty plea today?
Yes.
And is it your understanding that today you are entering what is called a non-negotiated plea of guilty?
Yes.
Now, do you understand that the state can recommend a sentence to the court in exchange for your non-negotiated guilty plea, even without your having agreed to it in advance?
Yes.
And have you discussed what the state's recommendation is going to be with your attorney?
Yes.
Are you aware that in the case number ending 989 that charges you with murder in the second degree, the state's recommendation is going to be that in exchange for a plea of guilty to a single count of homicide by vehicle in the first degree, that you be sentenced to 15 years to serve 7 in custody with the balance on probation?
Yes.
Okay. And are you also aware that the state is going to recommend a dismissal of all the remaining counts of that indictment?
After you said if I'll accept it?
Correct.
Yes, I'm aware.
And are you,
I'm gonna pause you just for a sec.
Yes,
Ms.
Judge.
Vaughn, when you say accept it, this is a non-negotiated plea, so if you plead guilty, you're not accepting the state's recommendation, but if ultimately you accept the sentence I impose, because I'm not bound by their recommendation of 15 to do 7. I'm also not bound by whatever Ms. Rios is gonna recommend. It's gonna be something less than 15 to do 7. I'm gonna make my own decision. X is gonna be my decision. If you accept that, then in fact, the state will dismiss all the other charges in the indictment.
Okay. Yes, sir.
okay. So Ms. Vaughn, are you aware that the state is also going to recommend that as conditions of your probation, that you'll be required to submit to a substance abuse evaluation and to comply with any recommended treatment, that you will have no drugs or alcohol while on probation, and that you will not operate a motor vehicle while you are on probation?
Yes, sir.
Okay. And Ms. Vaughn, turning then to the case number ending 011, are you aware that the state is recommending a sentence of 2 years probation on that case?
Yes, sir.
And as to the case number ending in 011, is it your understanding that you're entering what's called a negotiated plea of guilty as to that single count of theft by conversion?
Yes, sir.
And you're aware, again, though, that the court is not required to accept the state's recommended sentence?
Yes, sir.
And do you understand that the court does have the right to sentence you to the maximum possible sentence for that charge, even though it is what we call a negotiated guilty plea as to that count?
Yes, sir.
Returning then to the indictment ending 989 that charges you with murder in the 2nd degree, you understand that the court can impose any sentence authorized by law?
Yes, sir.
And do you understand that that could include a higher sentence than that is recommended by the state up to the maximum possible sentence for the charge of homicide by vehicle in the 1st degree?
Yes, sir.
And do you understand that homicide by vehicle in the 1st degree carries a potential sentencing range between 3 and 15 years in custody?
Yes, sir.
Now, do you understand that because you are at final plea today, that if the court imposes a sentence, you will have the right to withdraw your guilty plea if you choose not to accept the court's sentence?
Yes, sir.
Now, Ms. Vaughn, are you currently on probation or parole?
No, sir.
Do you understand that if the court chooses to sentence you to a term of probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal, while you are on probation?
Yes, sir.
And do you understand that you must follow all of the special conditions of your probation, whatever conditions the court ultimately chooses to impose?
Yes, sir.
And do you understand that if you were to fail to follow the special conditions of your probation, that you could be subject to a revocation of your probation for the balance of your sentence?
Yes, sir.
And do you understand that because you are entering a plea of guilty to a felony offense, you would not be allowed to receive, possess, or transport a firearm in the future?
Yes, sir.
And do you understand that doing so could result in a new criminal charge for which you could face a sentence between 1 and 5 years in custody?
Yes, sir.
Now, Ms. Vaughn, do you understand that by entering a plea of guilty, you're waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that by pleading guilty, you are giving up a number of rights, including the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of your attorney at a trial, the right to the presumption of innocence, and the right to appeal if you were convicted of these charges at a trial?
Yes, sir.
Is it your decision to waive those rights, which means not to use them, and to enter this guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No, sir.
And is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
All right. Ms. Vaughn, in indictment number 23 SC 191989, how do you plead to the single charge of homicide by vehicle in the 1st degree?
Guilty.
Okay. And in indictment number 21 SC 179011, how do you plead to the single charge of theft by conversion?
Guilty.
Are these guilty pleas freely and voluntarily given with full knowledge of the charges against you?
How can you say that again? I'm sorry.
Sure. Do you understand that this guilty plea, is it being given freely and voluntarily,
yes.
and with full knowledge of the charges against you and all the facts and circumstances related
Yes,
to
sir.
those charges?
Yes, sir.
Okay. Now, Ms. Vaughn, do you understand that if the court imposes a sentence that you ultimately choose to accept, you would have only a limited right to appeal your guilty plea conviction?
Yes, sir.
And do you understand that you would have only 30 days from today to file a direct appeal of your conviction?
Yes, sir.
Do you understand that you would have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes, sir.
And do you understand that if you wish to challenge the voluntariness or any constitutional aspect of your guilty plea, you must do so by filing what's called a habeas corpus petition?
Yes, sir.
And do you understand that because these are felony offenses, you would have only 4 years from today to file a habeas corpus petition?
Yes, sir.
And do you understand that unless she chooses to withdraw, your attorney will represent you until the end of the current term of court or 30 days from today's date, whichever is later?
Yes, sir.
And you understand that any of the filings that we've just discussed must be filed by your attorney unless you choose to represent yourself?
Yes, sir.
Okay, thank you very much, Ms. Vaughn.
No problem.
Your Honor, regarding the factual basis for these pleas, beginning with the case number ending in 989, on December 13th of 2020, officers with the Atlanta Police Department were called to respond to a report of an accident with multiple injuries on I-285 southbound at Arthur Langford Parkway. There were 4 different people involved in the collision of 2 vehicles. All had been transported from the scene by ambulance at the time that investigators with the accident investigations unit arrived on the scene. That unit completed a full investigation into the circumstances surrounding the vehicle crash, and the results of that investigation were the following: that on the day in question, December 13th, a 2017 Chevrolet Cruze that was being operated by Ms. Vaughn struck the face of a guardrail on the west side of I-285, about 50 feet north of the exit ramp to Campbellton Road. The Chevrolet came off of the guardrail, crossed all 4 lanes of travel before striking the median wall, and then was rear-ended by a Nissan Altima that was being driven by a Mr. Kebre, Kebre, Whitelock, Whitelock. The investigators obtained a warrant to conduct a search of the airbag control module. And once obtained from the Chevy Cruze, they learned that the Chevy Cruze that was being driven by Ms. Vaughn was traveling at about 75 miles per hour when it struck the guardrail north of the exit ramp. It also indicated that there was no braking by the driver during the collision and that there was no steering correction once the vehicle left the roadway. Ms. Vaughn's 2 children, 3-year-old Sameze, S-A-M-E-Z-E, Vaughn, and his 8-year-old brother Saw were unrestrained inside of the vehicle. 3-year-old Sameze was in the back passenger seat and Saw was in the front passenger seat. Neither of them were wearing seat belts or were in any type of car seat at the time of the collision. The 8-year-old Saw suffered a broken collarbone and some other injuries, but ultimately recovered. But 3-year-old Sameze was transported to Children's Healthcare of Atlanta, Eggleston Children's Hospital, where he was later pronounced deceased. The doctors confirmed that the cause of his death was blunt force trauma as a result of the vehicle collision. The investigators with the accident investigations unit ultimately determined that weather, roadway conditions, time of day did not play any kind of role in the accident. Grady Hospital, while treating Ms. Vaughn, did obtain a blood sample, and a later toxicology screening showed the presence of benzodiazepines and fentanyl in her system. There would have been no medical reason for the presence of the benzodiazepines or the fentanyl, neither of which had been prescribed to her or administered to her during the course of her treatment at Grady Hospital. The 8-year-old Saul, who was also involved in the collision, also reported to his guardian that, quote, "Mama took some pills and kept falling asleep." And so ultimately the investigators ruled that the cause of the collision was a result of Ms. Vaughn ingesting the benzodiazepines and fentanyl and most likely falling unconscious at the wheel of the vehicle. Turning then to case number ending in 011.
Before you get there.
Yes, Judge.
How did Mr. Whitelock do? Is he okay? Did he get injured?
So, Judge, I did try to look to see about the extent of any injuries to Mr. Whitelock, only that he was injured, but unfortunately I don't know any of the details of his injuries. It seems like the investigators obtained warrants for the medical records related directly to Ms. Vaughn and her children. Ms. Rios might be able to correct me on that. But he was transported from the scene by ambulance, as all four of the parties that were involved in this crash were. In the case number ending in 011, Ms. Vaughn essentially rented a vehicle from Hertz Rental Car Company and kept it then the longer than the rental period that was provided for under her contract. And Hertz reported that vehicle stolen. And so that is the basis for the other indictment. Ms. Vaughn does have 3 arrest cycles, but no prior felony convictions. And 2 of those arrest cycles involve the charges in these instant indictments. And looking into her history, I was unable to find any instances of similar conduct with respect to the operation of the motor vehicle while under the influence of drugs.
Okay. Saul, how do you spell Saul?
Saul, I'm sorry, Judge, S-A-U-L.
Got it, like King Saul, got it. And Saul is in whose custody now, if you know?
He's under the care of a guardian. One moment, Judge.
I don't need the name, but Saul, it's not that Saul is with defects. There's a guardian in the mix.
It's my understanding that he's in the custody of a male guardian who he made the outcry about the sort of nature of the collision to.
Okay, all right, appreciate it. Ms. Rios.
Yes, Your Honor. Ms. Vaughn is 32 years old. I wanted to give some background about what was going on in her mental state when this incident happened. So she lost her mother, who she was living with, 2 weeks before this incident. And I believe a month before that, her dad also passed. So she lost pretty much all her family. She doesn't have any relationship with, I think, her only sibling, her brother. And she was living with her mom at the time, and her mom was paying bills, the house. So that when her mom passed, it left her homeless. So
And was her mother's passing a sudden situation?
I-
Or it was building up because of a long-term illness?
my understanding was sudden, right?
She had diabetes. And she just passed away.
So it seems like she had an underlying health issue, but with diabetes, I guess.
It can be sudden. Okay.
So she was diagnosed with major depression disorder. And around the incident, of course, she had no intention of hurting her children. She thought she was okay to drive. And honestly, she just was going through a lot mentally at the time. Her son, she had told me that her son currently is in DFAC's custody, and she has been trying to see him, been trying to get him out. She wants to. She feels awful that he has gone through losing a sibling and now in DFAC's custody, and how traumatic that is for him. So she wants to be able to have a relationship with him, do whatever DFACS is requiring of her so she can eventually have custody of him again or be in his life. As you heard from the state, she doesn't have any instance like this. She doesn't even have an extensive criminal history, no felony convictions. So this was an isolated incident due to the grief that she was going through of losing 2 parents so suddenly close in time, and having the stress of having to still take care of her children and deal with this grief. And she seems to not have been able to get the mental health support that she needed at that time. And that's why this incident occurred. She's currently 7 months pregnant. She did have a relationship with the father. I have spoken with him and texted back and forth with him. I'm not sure the status of their relationship right now because he stopped responding to me. But
The father of the child to be, or the father of
that she's
Saul?
the child to be.
Okay.
He was supposed to bond her out, but he never bonded her out. And she does have a friend that she can go stay with, who I've spoken to, who.
Is this the same friend? I know when we had discussions about bond, Ms. Vaughn said, I've got this friend and that's where I can stay. Same person?
Yeah, same person. I've spoken to her a couple of times, and she can stay there once she, if she's released. And we're asking for 10 years probation, considering the circumstances of what led the surrounding circumstances of the incident. I think the fact that she's lost a child is punishment enough. Honestly, every time I come to see her, she's in tears. And so she's just I'm just hoping that she'll be able to be out and not give birth to her child in prison and be able to hopefully get her other child back with some support.
Ms. Vaughn, have you been able to get any treatment for grief and depression while you've been in custody?
No, sir.
Have you asked?
I haven't. I don't know who to ask.
Is there anything you want to add to what Ms. Rios shared?
She basically said anything. It's a mistake, sir. Honest mistake. Like, I didn't mean for it is that, but like, I just been going through a lot at the time. And I was just going to the quick trip distance park so I could go to sleep. And I don't want to have my son here. I just want to be with my son.
One second. Yeah, right there. I had a case similar to this recently. I'm just trying to get information on that.
Were you looking for me, Your Honor?
I was not. Thank you.
Oh, okay. I'm sorry. I thought I heard probation.
Oh, thanks.
Yes, Your Honor.
But we'll need you in a little bit, so don't go anywhere.
Right here.
Let me ask this while we're doing that research. Ms. Rios, no one talked about first offender. Is that not something you can get for homicide by vehicle? It may not be something for which Ms. Vaughn is. It sounds like she is otherwise eligible.
Yeah.
I just don't know if this offense of conviction is eligible for that, or it may be that you agreed you wouldn't seek that. I just don't want to leave it on the table if that was something we should have been discussing.
So that is something that we should discuss. I would want to know, can both cases be wrapped up in?
Oh, right, it's two cases. I forgot about that. They can be consolidated for purposes of sentencing, and we can do that. I'm not particularly focused on the Hertz case.
Yes. And I can quickly go over.
I'll handle that part if we're gonna do it, but I need to know if you can get first offender for homicide by vehicle in the first degree.
I don't know about that question, Your Honor, but unless both cases could be tried together, they can't be consolidated for trial for purposes of the code.
They would not be tried together. I mean, it would only be because the defense asked for some unorthodox joinder. They are unrelated in time, subject matter, etc. So then that sort of makes it move. I'm happy to do first offender on one of them.
Yeah.
If
well, I would request that we do first offender on one, because then it's just one conviction.
Okay. All right. Well, why don't I have that conversation? Oh, here we go. The info I needed just popped up. Thank you, Ms. Nelson. Okay, great. Mr. Shapiro, was there something you wanted to add, or?
Yes, Judge. Addressing the issue of whether or not Mrs. Vaughn is eligible for first offender treatment. doing a review of OCGA 42-860, it appears that while the murder charge would be ineligible for first offender treatment, homicide by vehicle appears to be a first offender eligible offense.
Okay, I'm gonna apply it to the theft by conversion anyway, just to have that have as little impact as possible on Ms. Vaughn's life. But let me talk about first offender with you, Ms. Vaughn. First offender is something that you are kind of eligible for. It's tricky because you have two cases right now. But for your Hertz car case, you are eligible for first offender, which is a situation where if I sentence you as a first offender, if you successfully complete your sentence, it goes away. It's not a conviction, and you don't need to report it as a conviction to anyone. Now, you're going to get a conviction flowing from the death of Samis. So in some ways, our discussion is a little academic, but I just want to make sure you understand how first offender works and that for your Hertz car case, I'm going to apply it, okay? Any questions about that? No? Okay. Ms. Vaughn, I find there's a factual basis for your plea in both cases. I hear you clearly that you didn't intend, who would intend to have what happened to Samis happen? And I know you will carry that as a burden everywhere you go, every day that you are awake and breathing, you are going to think about what happened. And so I don't look at you and think there's a killer. I do get cases where it's a cold-blooded killer who pulled out a gun and knew exactly what would happen when he pulled the trigger 14 times and shot someone. And that's not you. But we still have someone who, even though it was a difficult time and you had lost your parents, you made a series of decisions, it's not just one, that put your two kids in such grave risk. You as well. We're fortunate that you ended up okay. And it sounds like Mr. Whitelock was okay. I'm not saying that he doesn't have scars or still doesn't have a limp, but he clearly didn't die because there'd be a whole other charge that we're dealing with. And no one else got hurt. 285 is a scary place to be going that fast when you're sort of drifting in and out of consciousness. And that degree of recklessness, I think that's a fair word. It's not evil intent or malice or anything like that. But that recklessness, that's something that carries with it some pretty serious consequences. I think you've already experienced the most significant consequence, the loss of your child, as in the child who's deceased. The potential loss of Saul, I don't know that the people who make those decisions will say that it's okay for Saul to be back in your life. I hope so, for your sake and for his, but I don't control that. But I just want to emphasize that I appreciate Ms. Rios's perspective on this, but this is more than just a mistake in my mind. A mistake would be when you're closing the car door, you didn't notice that Saul's hand was sort of in the way and you accidentally closed the car door. One little thing, and that's terrible, and you would never want to do that to someone. And we rushed Saul to the hospital. But this was a series of things that resulted in a much, much more serious consequence. With that in mind, I find that there's a factual basis for both your pleas, that your pleas were knowing and voluntary. Knowing means you've understood all the things we talked about. Do you agree with that?
Yes, sir.
And voluntary means that no one's forced you to enter these pleas, but you've decided after thinking about it a lot, talking with Ms. Rios, that this is the way you want to move forward. Is that correct?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And that means that while you're on probation, if you have a small problem on probation, you and probation will work to resolve that. But if it is more significant, you get arrested for something, that comes back to me, and I will work through the consequences there. Ms. Rios, do you authorize someone in my office to sign the two indictments on your behalf?
Yes, sir.
Mr. Shapiro?
Please, Judge.
Ms. Vaughn, is it okay if we electronically put your name on the indictments indicating your pleas?
Yes, sir.
Okay, we'll do that. Ms. Vaughn, in 21 SC 179011, I will sentence you as a first offender. And I'm sentencing you to 2 years to serve on that case. In 23 SC 191989, I am sentencing you to 8 years to serve 2 years with a balance on probation. You will get credit for the time that you've served. You will have additional time that you need to serve. All the other counts will be dismissed. So that's count 2 that I have that sentence for you. The 2 sentences will run together. So it's a total of 8 years to serve 2 years. Again, credit for the time that you have served. A special condition of your probation is that when you are out and reunited with friends or your kids, that you submit to a mental health evaluation, so that if there's medication that you should be taking that will help you work through the depression and other issues you may have, you'll get some treatment. And if any treatment is recommended, that becomes part of your probation. So if that's go to counseling, take medication, you complying with that treatment is part of your probation. And I will also have as a condition of your probation that you get your GED. You got partway through high school, but I want you to get your GED because you're going to want to be working so that you can provide for your family, and your GED will help with that. So it's first offender, 2 years to serve on the Hertz car case, and it is 8 years to serve 2 years with a balance on probation for your vehicular homicide. Those 2 cases run concurrently. You get credit for time served. That's different from what Ms. Rios asked for. It is also different from what the state asked for. It is consistent with another case that I handled recently with a similar scenario where a mother, instead of fentanyl, it was alcohol, doesn't matter, and she drove and her child was unrestrained and her child died. And it was nothing intentional, but it was a series of really bad choices that had horrendous consequences. I think it's important that those sentences align a fair amount. And that's just so people understand the origin of where I come in between the 2 recommendations. But today is the last day you could withdraw your plea if you don't like the sentence you get. And that's okay. We'll get you back where you were. And it just means that we're going to have a trial on the case. So we'll need to bring Saul in to testify and the officers in, and they'll find Mr. Whitelock and he'll testify. But you have an absolute right to that trial with Ms. Rios as your lawyer to get you through that if that's what you want to do. I'm going to ask the 2 of you to talk for a little bit so that Ms. Rios can give you her thoughts about whether you should go forward knowing your sentence or instead withdraw your plea, which is fine. There are no negative consequences for you. And instead go to trial, where if you're found guilty, it may be a very, very different sentence because all these other charges that are being dismissed won't be dismissed. The jury will hear about all of them. Do you have any questions of me before the 2 of you go talk?
So you said 2 years serve, 8 years, but serve 2 for the murder too,
Correct.
for the homicide,
Right.
and then I already did 5 months. So the other 2 years is not with the other, like.
Yeah, they're running at the same time. So you have 2 clocks that are ticking at the same time. The Hertz case is not going to change anything for you. I just gave it the same number and it's going to run at the same time. The one you should be focused on is the vehicular homicide. And you've heard what I am prepared to do. You come in here and accept responsibility, which you did. And you shared with me how terrible you feel about what happened, which I would expect. And I'm going to say one last time, I know you're going to carry that pain and that shame with you on, way past 2 years from now, way past 8 years from now. And frankly, that's part of the punishment that life is giving you for having done what you did. And I'm factoring that in. I don't think the state's recommendation was unreasonable, the 5 years. But I think that fits better if you had been more intentional about things, as in, I'm going to show you, Samis, I'm going to make you sit in the back seat instead of the front seat. And that wasn't what you were doing at all. You were in a real tough situation and made a series of very risky decisions that had bad consequences for people you care a lot about. And we're here now. Okay?
A question.
Yes, ma'am.
Do I serve this in county jail or prison?
You would go into the Department of Corrections. You would not be here you may be at ACDC, but you would not be in the collection of county jails.
Okay.
All right, Ms. Rios, why don't you speak with Ms. Vaughn and let me know what we're gonna do?
We've discussed, Your Honor, and she would like to move forward, please.
Okay. Ms. Vaughn, I'm gonna see if Officer Evans, who is with probation, needs to give you any reporting instructions. I think it will simply be upon your release, you need to report, but let's hear from Officer Evans.
Yes, Your Honor. I'm sorry.
We're ready for you. Ms. Vaughn is going forward with her plea. In one case, there's no probation, and in the other case, there is probation, but it will be after she completes service of some time in custody. So I just want to make sure if there are things you need to tell her, you get a chance to do that.
Yes, Your Honor. I can provide reporting instructions, although we know that she'll be in custody for quite some time. If I could just have your address, your current address, Miss Vaughn.
I don't know that she's got one.
Okay.
I can just give the friend's address. I'm not
Okay.
sure, yeah.
So there was a friend with whom she was going to stay when she got out. We never locked that down. So I don't know that that's an address that you should put in the system. I think it would be safer to just let Ms. Vaughn know when she needs to report.
Yes, Your Honor. Miss Vaughn, you're going to report to 276 Memorial Drive, Southwest Atlanta, 30303. Telephone number 404-463-0410. You're going to report there within 48 hours of your release. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
And if you could just provide a good contact number for possibly like your mother or your sister or even your friend, someone we will always be able to contact.
My friend, I don't even have the number though.
Okay, don't worry about it. Just report to that address and that telephone number once you are released, okay?
Ma'am.
All right. Thank you, Officer Evans.
Thank you, Your Honor.
Thank you, Ms. Rios, for your work on behalf of Ms. Vaughn, and Mr. Shapiro for filling in for that lazy bones.
Can you let my friend know what happened?
Mr. Jordan.
Of course, Judge. Happy to do it.
Say that.
Your Honor, I think that concludes my business.
You want me to
Excuse-
call?
Yes, sir.
Thank you.
You burn them or something? I'll call.